Afternoon. We want to welcome everybody to our workers' compensation webinar from Lewis Thomason. I don't want to say annual because my hope is that everybody's work environments will change so that we can be together once again and we won't always be visiting virtually. My name is Leslie Bishop. I'm the chair of the workers' compensation group for our law firm. And I want to welcome you and thank you for your time and joining us today. We have several speakers lined up. The good thing about the webinar is that we are able to have folks from each one of our offices take some time out and speak with you today. What we're going to do is ask everybody to please mute their microphones so that we don't hear background noise. And also, I would ask that you hold your questions until the end. All of us will be available to answer those. And I'd like for you to send those through the chat function of Zoom, if at all possible. That way, everybody will have an opportunity to see them and make sure that we're able to answer your questions. As you all know, Lewis Thomason is a statewide law firm. We handle everything from divorce to construction law to taxes, along with workers' compensation. We have well over 115 qualified lawyers to assist you. One of our speakers today, Kristen Blackburn, actually has a license in Kentucky. So for those of you who may have questions about Kentucky law, she's your go-to gal. Without any further ado, I'm going to turn it over to Tyler Smith, who is in our Knoxville office, and he is going to speak to you and give a general overview of the workers' compensation system called Workers' Comp 101. Thanks again.
Thank you, Leslie. I hope everybody can hear me. We've talked about this, we've entitled this first part Workers' Comp 101 because we want to look at some basic concepts of what makes an employee's injury compensable under our workers' compensation statute. And I want to throw out a disclaimer first that every workers' compensation case is very fact specific. This is not meant to be a one size fits all. And I like to say that workers' comp cases are a lot like snowflakes. They can look similar from a distance, but once you get up closer, you'll see that each case is unique. And that's because you're dealing with a different person, a different employment relationship at a different time. So I would recommend consulting with an attorney for your specific case so you can get some specific advice on the case that you're dealing with. But what we're going to do is look just at the basic concepts and about whether an employee has sustained a compensable injury. And what we mean by compensable is there something that triggers the liability of the employer, triggers the duty of the employer to provide medical and possibly disability benefits. And we'll do that by looking at the statutory definition of injury first, and we'll break that down in pieces, and then we'll look at some of the available defenses. And throughout this presentation, we're going to talk about ways that we can prepare a case for defense and hopefully resolution. One of the next things you'll see is that at the outset, there's a distinction we make between the old law and the new law. Our legislature likes to tinker with the workers' compensation statutes every 4 or 5 years. So the last big legislation that we had came and applies to injuries that occur on or after July 1, 2014. So the injuries that are older, that occur before that, we call that the old law. And so the thing you'll need to know is if you're dealing with an older case, just consult with your attorney. There's some different procedures that may apply and some different processes. But for today's purposes, we're going to look at the new law, what we call the new law. That's injuries that occurred on or after July 1, 2014. And that's when we went to a completely administrative court system. And looking at the statutory definition of injury, and this was revised under the new law, was made much broader. And what that says is that an injury means an injury by accident or a mental injury, occupational diseases, including diseases of the heart, lung, and hypertension, cumulative trauma conditions, including hearing loss, carpal tunnel syndrome, or any other repetitive motion conditions. They are compensable if they arise primarily out of and in the course and scope of employment, and they cause death, disablement, or the need for medical treatment of the employee. And so you're going to see some important reoccurring points in this statutory definition. The first being that there has to be an injury by accident. And this can be a specific incident or a set of incidents that arise from the employment. And that's unique to Tennessee in a way. I know in some other states it has to be a specific acute event, a one-time injury. In Tennessee, it's much broader. It can be a specific acute event, it could be a set of events, or it could be gradual in nature. The second thing you're going to see is this arising primarily out of element, and that's your medical causation issues. And that's just the basic question of why. And why does the employee need medical treatment? And you're going to look at what the doctor says a lot on that. The third thing we're kind of going to cover is this in the course and scope of employment element, and that's just your time, place, and circumstances. So basically, where and when did the injury happen? And finally, the injury must cause death, disablement, or the need for medical treatment. And that just means, of course, that has to be serious enough that the employee is going to need benefits. The next subsection of this statutory definition of injury is a little confusing, but I laid it out there. It deals with pre-existing conditions. And basically what this section says is that if you have an injury that aggravates an employee's pre-existing condition, that can be compensable if the doctor says that the primary need for treatment is related to the work injury. And I wanted to touch briefly on occupational exposures. Actually, under the old law, we had a separate statute that dealt with occupational exposures, but this, when the statute was revised, the statute got much broader as far as the definition of injury, and so it's kind of included in what we read before. And we can make arguments that the employee would have been equally exposed to this same hazard outside of the employment, but what you're going to see is that courts are probably going to find the injury is compensable if there was a work exposure, if there was a hazard at work that the employee was exposed to. And the basic question for that is this exposure or risk connected to the employment the primary cause of the employee's injury? And that's a very fact-specific question, and it's very dependent on medical proof. We see this a lot if you have insect bite type cases, struck by lightning, exposure to fumes, things like that. But it also comes into play when you're dealing with viruses. And of course, that should perk everybody's ears in our current climate, because you may have seen that there was some recent legislation passed that limited liability of businesses, especially with respect to patrons and things of that nature when you're dealing with COVID exposures. But that legislation specifically did not impact the workers' compensation statute. It left it alone. So if you're in a situation where an employee is able to get an opinion from a doctor that says their workplace, they were most likely exposed to COVID at work, that could be, there's a good chance the court could find that that would be compensable. Now, it may be hard for the employee to get that opinion, but that's going to be the standard that the courts are going to use. Looking next at this in the course of employment requirement. And again, this is the time, place, and circumstance. What our case law says that means is that this injury took place within the period of employment at a place where the employee reasonably may be, and while the employee is fulfilling work duties or engaging in something incidental thereto. So again, that's just the time, place, and circumstances. Where and when did it happen? Is the employee where they're supposed to be doing what they're supposed to be doing? Our case also shows that an employee is not acting within the course of employment when the employee is going to or coming from work unless that injury occurs on the employer's premises. So that's what we call it. We have the coming and going rule, and you'll see some exceptions to that. But generally, an injury has to occur on the employee's premises. Now, in that, our case law makes clear that personal comfort activities on the premises can be compensable, even though the employee is technically not working. If they're injured while they're in the break room, they're injured going to a smoke break, going to use the bathroom, even though they're technically not working at the time, that's going to be considered in the course of employment. The cases also show that it includes not only the time which the employee is actually paid, but also a reasonable time during which they're on the premises going to and from work. So that's the situation where your employee clocks out and they're leaving the building and injure themselves then. That's going to be a compensable type injury. Looking next at just to kind of show the extent of what the employer's premises is, we include this section on parking lots because we get a lot of questions about injuries to employees in parking lots. And the general rule for that is that if the employer has provided a parking lot, the parking lot is considered part of the employer's premises, regardless of whether that lot is also available to customers or the general public. And our case law shows that the basic test for that is if your employee is injured en route to and from work. The injury is in the course of employment if it occurs on the premises or a necessary route between the workplace and the area provided for the employee's parking. And they make the distinction that once the employee has exited the parking area and they begin traveling on personal time, they are no longer in the course of employment at that point. So that's, again, that basic coming and going rule. Now, there are some exceptions to that, and those would be a few that the case law has pointed out, one being the special errand rule, and that's where your employee is being paid and they're being sent off premises to perform some type of special act or assignment. If they're injured doing that, that's going to be considered compensable. If they have a company vehicle that's furnished by the employer, they can be injured traveling to or from work, that generally might be compensable as well. And then also a situation where you have an employee who has some carpentry tools or tools and they need to travel to a job site and they're receiving a reimbursement for that. That's going to be considered in the course of employment as well. And the last big exception we want to hit on when you're dealing within the course of and scope of employment is your traveling employees. And the case law is pretty clear that your traveling employees are going to be considered pretty much in the course and scope of employment the whole time they're traveling. You see in that bottom section there, we talk about the injury or death of a traveling employee in a reasonable recreational or social activity is considered in the course of employment. A simple example of that is if you have an employee who's staying at a hotel and goes and works out or exercises and injures himself doing that, even though they're not technically working at the time, they are considered in the course of employment because they are a traveling employee. All right, our next element in this basic definition of what makes a injury compensable is this arising out of element. It's the medical causation issues, and it's just a simple question of why. Why does the employee need medical treatment? What is the primary cause of that? And again, we're talking about the cause and origin of the injury. And our cases say that in all but the most obvious cases, such as an employee losing a limb, that relationship to the work has to be established by expert medical testimony. And we argue about and litigate medical causation probably more than any other issues because it is complicated and it does rely on expert medical proof. And that standard is the physician is going to have to say within a reasonable degree of medical certainty, just means they're not guessing, they're not speculating, that the injury or the need for treatment was more likely than not primarily related to the employment. And again, more likely than not means just greater than 50%. And so some of the questions that you're going to want to ask the doctor when you get in these situations is not only what is the employee's current diagnosis, do they have any type of pre-existing conditions that could contribute to this need for treatment, and what is the primary cause of the need for treatment. And I would say at this point that, instead of doing a simple check yes or no type letter to your doctor, I would recommend getting an attorney involved and putting in some work here because you want to make sure the doctor has all the information, all the records, and you want to make sure they can make an informed opinion because the opinion of your treating physician is going to be absolutely vital on whether or not a claim is considered compensable. And we know that because in the next section of this statutory definition of injury, you'll see that the opinion of the authorized treating physician, that's the physician that's selected from the panel, they get the choice of three, they choose one. The opinion of that doctor is going to be presumed correct on the issue of causation. Now, this presumption can be rebutted, but it's very important. It's going to be very hard to do. So the opinions of that treating doctor are going to be very important of saying whether that need for treatment arises from the work injury. And we also know that the opinions of this treating physician are going to be, or the medical treatment recommended by this doctor is going to be presumed medically necessary. And that's going to come up. We're going to talk about utilization review here in a little bit, but that treatment recommended by the authorized treating physician is going to be presumed medically necessary and reasonable. Finally, just want to touch on a few defenses that could come up in your workers' compensation cases, the basic being the statute of limitations. If your employee wants to preserve their claim and keep it from being dismissed, the employee has an obligation to file a petition for benefits determination with the Bureau of Workers' Compensation. That's just a form pleading with the Bureau. They have to make that filing within 1 year of the date of injury or the last date of voluntary payment on the claim or the last authorized treatment, whichever is later. And whichever is later is key in that consideration. Looking at just a few defenses that could come up and to consider in any case, was there illegal drug or alcohol use at or near the time of the work injury? You would want to look at, is there any type of willful misconduct, such as failure to use the safety equipment that the employee was specifically instructed to do? Is there a misrepresentation in the employment application? Is this person that's injured actually an independent contractor? They're not an employee. And finally, the last injurious injury or exposure rule. And what that means is basically after you've had the work injury, there's a separate injury that occurs later, or it could be a situation where your employee is started working for another employer and that work has permanently aggravated their condition. All those things are things that you can consider to look at whether or not the case may be compensable and what would trigger your obligation as an employer to provide medical benefits. And so that's some big picture things to consider when we go through this and looking at whether the employee is entitled to benefits under our statute. And with that kind of basis in mind, we'll look forward to our next section, which deals with how our court system is set up and how workers' compensation claims are handled administratively. And presenting on that topic is Patrick Quinn in our Memphis office.
Well, thank you, Tyler, and good morning, good afternoon if you're on Eastern time. As Tyler said, my name is Patrick Quinn. I practice in Lewis Thomason's Memphis office, and I'd like to guide you through kind of a brief overview of Tennessee's workers' compensation system. So we heard Tyler discuss the 2014 Tennessee Workers' Compensation Reform Act, which was implemented in 2014. And the act created this new administrative court of workers' compensation claims operating within the Tennessee Bureau of Workers' Compensation. So in addition to the administrative law judges who were created and assigned under the Reform Act, the Bureau also employs a wide array of professionals, some of whom are listed here, that you may encounter in the course of a typical workers' compensation claim. Now, Tennessee, the state of Tennessee is sort of subdivided into 8 regional offices of the Bureau of Workers' Compensation. The on-site approvals and mediations and any hearings are typically going to occur in that regional office where the employee resides. Now, typically, this is how things operate. Sometimes the benefit review process is farmed out to a mediator who may be in another region of the state, but almost always the in-person mediation itself will take place in that employee's local regional office. Now, the act, as we said, implemented some administrative trial judges, some of whom are pictured here. There's 12 judges in all who serve under a chief judge and the bureau administrator. All of these individuals have an extensive background in workers' compensation, and they only hear workers' compensation cases, so they're very specialized. Their main duties include approving settlements, setting scheduling orders, conducting hearings, and of course, ruling on motions and presiding over trials. In addition to the administrative trial judges, there's a 3-judge board appointed by the governor and exists separately from the Court of Workers' Compensation Claims. They are tasked with deciding appeals of orders from our trial judges. Normally, that's typically done without oral argument. So the basic course of litigation for workers' compensation claims in Tennessee is going to follow the sequence that's set out here. First, a petition for benefit determination is filed by the employee, after which a mediation is held. Sometimes that's an informal proceeding, sometimes it's formal. Once the mediation is complete, a dispute certification notice is issued by your mediator. At that point, the employee has 90 days to request an expedited hearing or request a scheduling conference. So once your initial hearing or scheduling conference has occurred, that opens a period of discovery and medical proof. Once that sort of discovery period is complete, we have another mediation pre-trial. And if the case does not settle at that point, it'll proceed to your compensation hearing. And That's our trial in workers' compensation terms. Now, according to the Bureau's 2018 annual report, the vast majority of PPDs that were filed actually resolve in mediation before a DCN is even issued. So most of these claims aren't even getting to court. Of those claims that do make it to court, very few hardly ever make it to a compensation hearing. So as a result, most attorneys recognize that the expedited hearing or mini trial is usually the most important part of your of the litigation process under the new law. So we're going to talk a little bit about that now. What is an expedited under workers' comp? Well, it's a hearing of narrow scope that is held to determine temporary disability and or medical benefits, and that's it. So either party can request an expedited hearing after the case is docketed, and the party who requests it is required to present an affidavit in support of their case. Now, the opposing party then has 5 days to provide some countervailing evidence or indicate the need for a full evidentiary hearing. At this point, the judge presiding over the case can determine if a hearing is necessary, or they may just go ahead and enter an order based on the documents that have been produced at that point. Now, this is kind of an important distinction between old law and new law. Under the old law, the evidentiary standard for statutory interpretation was known as remedial construction. And basically that means all reasonable doubts should be resolved in favor of the employee. It's employee friendly. That's no longer the case. Now, under the new law, this legislation includes a specific statutory provision which departs from the old law standard, and it states, quote, that the statute should not be remedially or liberally construed, but shall be construed fairly, impartially, and in accordance with the basic principles of statutory construction. All right, so we have a different standard under the new law. So at the compensation hearing, the employee has got to prove that they are eligible for workers' compensation benefits by a preponderance of the evidence, meaning that more likely than not, the employment, whatever it was, contributed more than 50% in causing the disablement or the injury or need for medical treatment. It's an important distinction. Now, another important distinction is with the expedited hearing versus the full trial. At an expedited hearing, an employee only has the burden to come forward with sufficient evidence to show the court that the employee would likely prevail at a hearing on the merits. All right, so this has been interpreted by Tennessee courts as a lesser evidentiary standard. And the employee has, frankly, just a lower burden of proof at this expedited hearing stage. The employee in an expedited hearing does not have to prove by preponderance of the evidence that he sustained a compensable work injury. They only have to show that they could likely prevail at trial based on records and testimony that they present. So we have some case law that address the evidentiary standard set out in the statute as applicable to expedited hearings. And in this case, Buchanan versus Carlax Glass, the court found that indeed this is a lesser evidentiary standard in expedited hearings for the employee. And relief can be granted if evidence doesn't rise to the level of a preponderance of the evidence. So that's very important for the employer and the employer's attorneys to keep in mind as they move through these cases. Now, what about defending cases? From our standpoint as defense counsel, we have to be aware that at an expedited hearing, the employer is not likely to prevail if their only defense is that the employee can't prove a work-related injury. That's not going to cut it under the new lesser evidentiary standard. The trial court is generally likely to rule in favor of the employee if the employee presents uncontroverted testimony or some subjective history that might be shown in medical records or other evidence that they bring forth. So it's important for the employer in the expedited hearing stage to come forward with some sort of evidence. It can be, testimony from a witness, medical records, photos, surveillance, etc., to support the denial of benefits and to undercut the employee's claim. So as defense counsel, it's important for us, as we defend these cases, to be aware of these evidentiary standards early on. When we begin to investigate and defend a workers' comp claim, we try to focus on gathering evidence early on in the process in the form of any sort of documentation. Videos or photos are great. Could even be a potential witness, and medical opinions are especially helpful. Anything that will help to disprove or undercut an employee's theory of recovery, if that theory is in doubt. Getting a hold of this documentation early on in the process is certainly preferable. This can help limit and rein in the employee or the employee's attorney from expanding and developing their claim under new theories. The employer, if at all possible, should not remain silent on an issue raised by the employee, as this generally favors the employee's theory of the case. Employees can explain a version of the events that favor their case. So it's good. It's always good to gather as much evidence as possible early on as possible in these claims. And that's sort of a main key for defending them. So with that, I'm going to pass the baton to Lynn Peterson. Lynn's a shareholder in our Knoxville office, and she's going to be talking with you about utilization review.
Good afternoon, everyone. Thank you for attending. As Patrick said, I'm in the Knoxville office. I've been defending workers' compensation cases for over 30 years. And one of the most expensive items of a workers' compensation case is the medical that you have to pay on these claims. And under Tennessee's workers' comp system, there are some ways that you can control those medical costs. Obviously, you provide the list of physicians, and that's one way to control costs. There's a medical fee schedule that can be used, which is another way. And then I'm going to talk about utilization review, which can be utilized to make sure that the amount that providers are charging for their services for workers' compensation patients is medically necessary. And what utilization review does is provide a mechanism for employers to review and evaluate the cost, the reasonableness, and the necessity of the recommended medical services. If the treatment that's being recommended by your authorized treating physician is disputed, then this is what you should send to utilization review. This review is done before the procedure is performed to ensure that it's appropriate, necessary, and likely to be effective. And you can send for utilization review all medical procedures and tests recommended by the authorized treating physician and all hospital admissions with the exception of emergency services. However, you cannot obtain utilization review for diagnostic procedures that are ordered by the authorized treating physician within the first days after the date of injury. Utilization may also not be used for diagnostic tests when the initial treatment has been non-surgical, no diagnostic testing has been completed yet, and the employee has not returned to work. So the intent of those two prior rules that I just went over when you cannot use utilization review is to really make sure that the medical treatment at the outset of a claim is not delayed by disputing medical necessity just as a matter of course. It really appears that what the legislature did not want to have happen was all medical treatment be disputed right at the outset of a claim, especially when early treatment is often critical to a good outcome for the employee. The decisions from the utilization review agent can only address medical necessity. They do not and will not comment on either causation or the issue of compensability. You need to know that an adjuster cannot deny recommended medical treatment as not being medically necessary. This can only be done by an advisory medical practitioner. So assuming you have a claim with a medical procedure being recommended, we're past the initial treatment phase, you can then refer the matter for utilization review so that you can decide whether this is the treatment that ought to be pursued. These are typically done for diagnostic tests that may have been done already, and you wonder, do we really need to do that again? It's done for things like discograms, epidural steroid injections, radiofrequency ablations, which all those things can be very expensive. So if you decide you want to submit something to utilization review, there are strict time limits for when you must make the request for UR. And if they are not followed, you may find yourself without the ability to question the medical necessity. An adjuster only has 3 business days after being notified by the provider of the recommended medical treatment to either approve the treatment or send the recommendation to utilization review. Once it's been sent to utilization review, they have 7 business days to make a decision on the recommended treatment. Now, everyone who's used UR knows that it rarely happens that quick. That's because the utilization review organization can ask for additional records if they don't have all of the information they need to make a decision. They have to request those records in writing, and then the authorized treating physician has 5 business days within which to provide those medical records. So the number of business days is extended until the URO receives the necessary information or until the 5-day business time frame expires, whichever occurs first. If they do not get the information that they've requested, they'll go ahead and issue an opinion anyway. And as you can imagine, not all physicians get them the information requested very promptly. And quite often we see decisions about medical necessity are being made without all the information needed. So if you see the utilization review organization asking for records, make sure that those records get sent, particularly if you think that this is medical treatment that ought not be approved. If the utilization review organization says that the treatment is approved, that decision is final and it is not subject to appeal. However, if the treatment is denied, then the report has to state the reason it was denied, and it has to give the name and credentials of the physician that made that decision. That denial is then subject to appeal. And so all of the denials also have to be accompanied by a state form so that the employee, their attorney, and the treating physician are all informed of the proper procedure that has to be filed to request an appeal. Once that denial has been sent out, the employee, the attorney, or the physician have 30 calendar days from the receipt of that notice within which to file an appeal of that decision. What happens then is the report and all the supporting records are sent to the Bureau's medical director, and then he or she determines if they agree with the UR denial. The fee for that review, of course, is paid for by the employer or the carrier. If the medical director disagrees with the UR decision, an order for treatment recommended by the authorized treating physician will be issued. If the medical director agrees with the UR decision, then the treatment will continue to be denied. If you have a utilization review decision that denies recommended treatment, it's going to remain effective for a period of 6 months from the date of decision, and no further action is necessary. And the treatment can continue to be denied even if your treating physician issues further orders, if it's for the exact same thing. There is a loophole that if the authorized treating physician can come up with a material change that supports a new review or some other pertinent information that was not used by the utilization review organization when they made their initial determination, then you can't stand on that denial and you have to go through UR yet again. Typically, treatment is denied when the ODG treatment guidelines are not followed, and that's typically the reason for the denials. Finally, there is, of course, a penalty provision. If the employer, the carrier, or a utilization review organization is found to have violated the utilization review rules, they are subjected to a penalty of not less than $50 nor more than $5,000 per violation. It's a great process. I know all adjusters use it. Employers need to be aware of it, and it will help contain medical costs for sure. So now we want to talk about impairment ratings, and I'm going to turn this over to one of our associates in the Knoxville office, Alana Beach.
Good afternoon. My name is Elena Beach. I'm in the Nashville office, and I'm going to be talking about the Medical Impairment Ratings Registry today. Just some background, I've been practicing workers' comp since 2010. 5 years were in South Carolina and 5 years here. So happy to talk a little bit more about it. The MIR program is a little bit less commonly used today under the new law, just because there's less discretion with regard to the judge's assessment of a rating. Generally, the authorized treating physician rating is going to win the day unless an IME shows why the rating is inappropriate or inaccurate. The MIR program can be used when there's a dispute as to the degree of medical impairment, and either party would like to request an independent doctor to provide an impairment rating opinion. The question is, what does a dispute mean? To get to that point, dispute means generally that there are going to be two impairment ratings, usually the ATP's rating and an IME, which can even be an IME from the employer if it results in two different ratings and there's a dispute on which one applies. However, dispute can also mean that the ATP has assessed a 0% impairment rating or says there's no impairment and either party disagrees. It can also be just a dispute in that both parties believe the rating assessed is wrong. To begin the MIR request process, the requesting party has to complete an application with specific questions. There's a very helpful website from the Department of Labor with information about the procedure. And I'll go to the next slide. The benefit for either party of an MIR is that the written opinion as to the impairment rating, which is given by the independent medical examiner from the MIR registry, is presumed accurate. So a lot of times if you get the MIR rating, you're stuck with that rating. However, the presumption can be rebutted by clear and convincing evidence to the contrary. The physician cannot provide any other opinions outside of the proper impairment rating. This means that he can't provide an opinion on restrictions or causation or really anything else. This has to be a physician with no ties to the case. So if the physician has previously been on a panel or had any prior dealings with the case, that has to be immediately disclosed. After the application is completed, either of the parties can agree on a physician from the MIR registry, or if they can't agree, the administrator provides 3 physician options and each party strikes one. Neither party can communicate with the MIR physician. There are specific rules and deadlines as to provision of medical records and what's needed to do the evaluation. So be careful to pay attention if you go through the MIR process, because the deadlines are very specific. Additionally, after the report is issued, an MIR is subject to peer review, which would be from a physician designated by the administrator. We can go to the next slide. One frustrating aspect of the MIR review process is that the employer has to pay for the evaluation, even if it's the employee or his attorney requesting the MIR. And this can be used as leverage from an employee or his attorney, because sometimes the cost of the evaluation is more than the difference in the two ratings. So it may sometimes be worthwhile to agree on a higher rating rather than go through the MIR process and risk the price of the evaluation and an uncertain outcome with regard to the final rating. The cost is generally $1,500, but it can be up to $2,000 for a psychological impairment evaluation. Really, the cost is going to depend on the complexity of the case. The longer the report takes, the lower the cost, so the MIR physician has an incentive to complete it quickly. The program coordinator can also increase the evaluation fee for up to an additional $500, depending on how complex the rating assessment is. There are also penalties, like in almost every area of workers' comp, penalties for late payment of required fees, late cancellation of the MIR evaluation, and failure to comply with the MIR rules. And the penalties can equal up to $5,000. Next, I'd like to introduce Kristen Blackburn, who will be talking about subrogation. She's in our Nashville office as well.
Hi, everyone. My name is Kristen Blackburn, and like Elena said, I'm in our Nashville office. I'm also licensed both in Tennessee and Kentucky. I also defend employers and carriers in workers' compensation claims, and also businesses when they're sued for tort damages. And so I'm very familiar with subrogation in Tennessee and how the statute works, having been on both sides of the V. And just so you guys know, when you are seeking subrogation benefits that you have, of the medical benefits that you've paid, you will be seeking those benefits as a plaintiff. You will be intervening or standing in the shoes of the employee as a plaintiff suing the third party. And so in a subrogation case, the employer carrier serves as the plaintiff. And the right of subrogation will arise anytime an employee is injured and you've paid medical benefits or indemnity benefits, and that injury is due to a third party's negligence. And so this statute, TCA 50-6-112A, provides the statutory right of subrogation and the ability of an employee to receive both workers' compensation benefits from you, the employer or carrier, and also receive tort damages from the person that injures them. And so going to the next slide, it says here, section 112C provides you with the statutory right. It says that if the employee recovers from a third party, either through settlement or judgment, and you have paid workers' compensation benefits, then you shall have an automatic right of subrogation. And you may even intervene in the employee's lawsuit to protect your interest. And that is a dollar-for-dollar subrogation lien. So for every dollar you pay, you are entitled to receive that dollar back from the employee's award. So let's talk about the kind of benefits that you can recover. You can recover all medical benefits that you have paid through the date of the employee's settlement or trial. You can receive all of the permanent partial disability benefits, the temporary total and temporary partial disability benefits, and any permanent total benefits that have been paid through the date of the settlement or the trial. There are certain benefits that we know you cannot receive, and the statute has not been discussed very often by the courts, but we can know from those court rulings the types of damages that employers cannot recover. You cannot recover future medical benefits, even if you are almost certain that they are going to be needed. You can only get medical benefits that you have actually paid through the date of the settlement or trial of that third-party tort lawsuit. You also are not entitled to receive case management fees, nurse case management fees that you have paid. I would extrapolate from that you would not be able to receive the UR fees that Lynn talked about. You won't be able to recover legal expenses that you've paid in your workers' comp or any kind of management fees, anything that would have reduced your workers' comp liability. You are not able to recover that. You're also not able to recover from the employee's settlement or judgment any damages that were set aside for the employee's spouse that's designated as loss of consortium. So under Tennessee's tort law, the employee's spouse can receive damages for the loss of companionship or loss of services from their spouse's injury. And if money has been set aside in the settlement or set aside in the judgment for loss of consortium damages, you cannot collect against those. The case law has also told us that you cannot recover from any suit against a co-employee. So if the employee sues a fellow employee and receives a recovery, you cannot subrogate against that recovery. We also know that even if the employee files suit in another state, say they were injured in another state, you are still able to intervene and you're still able to protect your subrogation lien in those others if they recover in another state. Also, if the employee dies and the case is pursued by their estate or wrongful death beneficiary, you are still entitled to recover the money that you have paid for medical benefits and TTD benefits or PPD benefits from the wrongful death beneficiary or the estate. So there are a number of ways that you can recover the money that you have paid. You have the right under the statute to intervene in the employee's lawsuit to protect your lien. That is the best way for you to make sure that you have control over collecting your money. As an intervening party, you are able to participate in all discovery, in any mediation or settlement negotiations, and an agreed order settling in that case cannot be entered without you being involved in that process. If you choose not to intervene and the employee's attorney pursues that recovery, part of that recovery will be pursued on your behalf. And so the courts say that they are entitled to 1/3 of your lien as an attorney's fee. And so you will have to carve out at least 1/3 of whatever you recover and pay that to the employee's attorney who pursued that claim for you. So if the employee decides not to pursue their third-party case against that tortfeasor, you still have a right to protect and recover the money that you have paid. Tony, if you'll go to the next slide. The employee has 1 year in Tennessee to file a personal injury lawsuit. That is the statute of limitations for personal injury suits in Tennessee. If they choose not to pursue that within 1 year, you as the employer or carrier have an additional 6 months to file a lawsuit against that third party that you think has legal liability for causing the employee's injury and leading to you having to pay these medical and indemnity benefits. You can file that lawsuit in the name of the employer or carrier, or you can file it in the name of the employee. So those are the rights that you have under Tennessee law to collect the money that you have paid back from a third party who caused your employee's injury. This is a high-level overview, so if you have any specific questions about subrogation in Tennessee or in Kentucky, please feel free to reach out to me. I'm happy to discuss any questions that you have. And now I'm going to turn it over to Susan Carey in our Nashville office, who is going to give you a case law update.
Good afternoon. I am presenting the case law update. The first case deals with issues of subject matter jurisdiction and election of remedies. The case of Goodwin versus Morristown Driver Services involved an employee who was a resident of Georgia who was driving a truck for a Tennessee employer and was involved in an accident. The employer filed a Tennessee first report of injury and paid for emergency medical treatment. Then the employee filed a Georgia comp claim. The employer responded that Georgia did not have subject matter jurisdiction, and so the employee filed a claim in Tennessee and pursued both claims concurrently. The Georgia board dismissed the claim and then moved to dismiss the Tennessee claim on the grounds that the employee had sought benefits in Georgia and that the Tennessee claim was barred by the election of remedies doctrine. The trial court found for the employee and the employer appealed. The appeals board reversed, emphasizing that the employee had engaged in extensive discovery in Georgia and had participated in a hearing in Georgia where he offered testimony and evidence in support of the merits of his claim. The appeals board concluded that the employee had knowingly elected to pursue workers' comp benefits. The employee appealed to the Supreme Court panel, and the panel reversed, reinstating the case, essentially ruling that an injured employee cannot elect a remedy that is unavailable, and that the Georgia dismissal for lack of subject matter jurisdiction, without regard to the merits of the claim, established that there was no remedy available to him in the state. The panel explained that the election of remedies doctrine aims to prevent vexatious litigation, forum shopping, and double recovery, but isn't meant as a trap or penalty for an employee's mistake. The second case deals with the issue of mental injury and reiterates the importance of obtaining medical proof when causation is disputed. This case involved a home health aide who injured her back at work in 2017. The claim was accepted as compensable, and she underwent surgery and was placed at MMI in 2018. She was referred to pain management and was prescribed Lyrica. In 2019, she told the ATP the Lyrica caused foggy sensorium, and she entered outpatient mental health treatment for severe depression. The employee wondered if Lyrica was adding to her depression and asked the ATP to refer her to a psychiatrist through workers' comp. The ATP made a referral to determine work-relatedness and encouraged the employee to continue her outpatient treatment under her personal health insurance. The ATP also took the employee off work due to depression secondary to Lyrica use and opined that Lyrica contributed more than 50% to the aggravation of her pre-existing condition, but said a psychiatrist should evaluate and state for certainty. The employer denied the claim and the employee filed a petition. Following an expedited hearing, the trial court ordered the employer to authorize the psychiatric referral, and the employer appealed. The appeals board noted that it was undisputed that the ATP referred the employee to a psychiatrist for an evaluation he opined necessary as a result of Lyrica use. The burden of proof was on the employer to show the referral was not medically appropriate. The employer took the position that the employee's mental condition was pre-existing and caused by events in her personal life, rather than the medication prescribed for her work injury. The board noted that parties and lawyers cannot rely solely on their own medical interpretations of the evidence to successfully support their arguments. Absent supporting expert medical proof, the employer's interpretation of the employee's medical records and its belief as to the cause of her current mental complaints was not sufficient to overcome the trial court's determination of the appropriateness of the psychiatric referral for evaluation and treatment. And the board affirmed the trial court order requiring the employer to authorize the psychiatric referral. The third case we're going to look at deals with issues of subject matter jurisdiction and mental injury. The case of Nickerson versus Knox County government. This case deals with an employee who alleged that she suffered a mental injury from working as a forensics technician for Knox County, investigating crimes against children. These investigations had occurred in 2011 or earlier. She was diagnosed with PTSD in 2018 and filed a workers' comp petition in 2019. The employer defended on the statute of limitations. The employee asserted that the statute was told until 2018 when she discovered that her mental condition was causally related to her employment. In the alternative, she argued that her mental injury was a gradual injury and that the last day work rule applied. The appeals board held that the date of injury is the date of the work incident resulting in injury, regardless of when the employee became aware of the injury. And because the employee viewed the crime scenes involving children in 2011 or earlier, the applicable date of injury was 2011 or earlier, well prior to the effective date of the 2013 Reform Act, and that therefore her date of injury deprived the Court of Workers' Compensation claims of subject matter jurisdiction. And the fourth and final case we'll look at deals with the issues of causation and a battle of the experts. The case of Johnston versus Siskin Steel involved an employee who had worked for Siskin for 39 years. He alleged that during those years, he had been exposed to heavy metal contaminants and that exposure had caused his various diseases. The first was liver disease. A hair test revealed elevated levels of heavy metal contaminants. The employee reported it to his employer, which denied his claim. The employee later suffered a heart attack and was diagnosed with chronic kidney disease. The trial court ruled for the employee and the employer appealed. The appeals board reversed and held that the lower court should have accepted the employer's experts because they were better qualified. The employee's experts were not board certified and relied on a screen that itself contained a disclaimer that it was to be used for educational purposes and not for diagnostic assessment. The employer's experts were licensed to practice medicine in Tennessee and board certified in their respective fields of treating liver, kidney, and heart disease. The board reversed the trial judge's order of open medical benefits and $172,000 in permanent disability benefits. In so doing, the board applied the long-standing test for courts to apply when expert opinions conflict, including qualifications and information which is available to the experts. And with that, I'll turn it over to Leslie Bishop.
Thank you, Susan. Well, I am going to talk with you all today about the legislative changes which we've had with workers' compensation this year. For some reason, our legislature can't seem to leave workers' compensation alone and seems to fiddle with it just a little bit every year. This year was no different. There are not any significant changes. However, one change that they made essentially extends the initial compensation period for all cases on or after June 22nd, which result with a permanent partial impairment rating right between 5 and 6%. In other words, if a claimant has a permanent partial impairment rating provided to them for an injury which occurred after June 22nd, 2020, then the legislature has extended their initial compensation period. For instance, under this law, if you have an injury on July 15th of 2020, and an individual is placed at maximum medical improvement on or about October 15th of 2020, under our old system, then the initial compensation period or availability for enhancements would expire on or about 11/16 of 2020. Under the new system, that's going to be extended for 180 days. In other words, it extends that initial compensation period for 6 months for any and all impairment ratings that are between 5 and 6%. It's 180 days. Well, the ramifications of that are that an individual is given a year from the extension of the initial compensation period in which they can file for enhancements. So this will extend that period of time another 6 months. And in this case, an individual would be able to apply for enhancements or aggravating factors until April 13th of 2022. The next slide, please. Another change has to do with the attorney fees being sunsetted. In cases where an employer has been found to have wrongfully denied certain benefits, the court is allowed to award attorney fees to be taxed against the employer to that employee. It's been fairly rare when it has been done in somewhat egregious cases, but now that provision has sunsetted. In other words, the court cannot assess attorney fees against an employer or a carrier unless it was an injury which fell between July 1st of 2016 and July 30th of 2020. That may be a provision that comes back depending on behavior of carriers and employers and defense counsel. Next slide, please. We also every year on July 1st look at the minimum and maximum that's going to be paid. This is based on information which is actually gathered from the Employment Security Department, and we set a new minimum and a new maximum for workers' compensation rates. Recall that workers' compensation rates for maximum cases have a higher rate of pay for temporary disability benefits than they may necessarily for permanent disability benefits. So as of July 1st, our new figures are an individual can draw $1,093.40 if they're at a maximum rate for a temporary total disability rate. Once they hit PPD, then that will necessarily be reduced to $994 per week if they qualify for the maximum. And in no case can an employee be paid less than $149.10. Where does that leave us? That leaves the maximum total benefit for an injury which would occur now or perhaps a death at $447,300. That's exclusive of medical benefits. So this is an area of the law that has a great expense to employers on it. Next slide, please. I wanted to also bring up briefly, since we have a few minutes here, where does Tennessee and its legislature stand on COVID claims? I want you to know that in the special session in August of 2020, this was brought up and it was proposed that Tennessee have one of the broadest essential business claims and presumptions presented. It died in the Senate, but this would have essentially been crushing to employers. Any and all, quote, essential businesses would have had a presumption that if they had COVID, it came from the workplace. So that was strongly defended, but they anticipate that that will come back. An essential business includes anything from manufacturing to banking to retail to lawyers, etc. So this could be a very widespread presumption. Where are the other states on this? Well, at this point in time, we have 2 states that have passed administrative rulings for essential workers to be covered, 5 states that have executive orders, and 9 states that have actually passed legislation. The rest of the states are operating under their old system and how it applies to COVID. So we will see where we end up with next year. At this point in time, if you all have any questions, there is a function where you can chat, and that will come to all the panelists. I do understand that somebody has asked about particular forms, and I guess I would need a little clarification on that to see exactly what the questions are as to what gets filed through EDI and what's required. I want to thank everybody for the time today, and again, if you want to send your questions in, we'll keep it open so